All right. Ms. Rivers, can you hear me now that I'm logged in?
Yes, I can, Judge. Good morning.
Good morning. Fantastic. Okay. We have a mixed calendar. People are on for different reasons, and I think a couple of people have come off. We'll go through in the order it was published and see what we can take care of. We're also live on YouTube. So I know we've got some folks brought over, and then some folks ideally will be coming into court from outside. Our first position is DeMarcus Brown. Is he here? What? He is. Okay. Good morning, Mr. Franklin.
Good morning, Ron. I believe Ms. Hall and I have a negotiated agreement on that case.
Okay. It's a lot of counts. Do you want to?
Oh, I'm sorry. Well, we're going to cover non-negotiated agreements. Non-negotiated case.
Okay. Mr. Brown is planning on going forward with a plea. It's non-negotiated. You want to do that now? Do you need to talk to him, or?
I spoke to him last night.
Great.
I'm prepared.
Let's do that. If we could bring Mr. I've got two cases on the calendar, although one doesn't list. Oh, it's a revocation, but that's crossed out. Maybe the revocation had already happened, or?
No, that hasn't happened.
Okay. For some reason, it's struck out on my calendar, but if we need to address that, and Mr. Franklin is prepared to, we'll handle that as well. But I guess it's a plea to the 20 SC case. And got that indictment right here. How many folks do we have in custody? 5. All right. Thank you. Good morning, Mr. Brown.
Good morning, Mr. President.
Are you ready, Ms. Hall?
I am.
Great. Okay, we'll go on the record. This is position 1. It's 20 SC 176-900, State versus DeMarcus Brown. Mr. Brown is here in court with his lawyer, Mr. Franklin. Ms. Hall is representing the state. And Mr. Brown, Mr. Franklin told me that you are prepared to enter a plea in your case. Is that correct?
Yes.
Okay, this is a non-negotiated plea as I understand it. So Mr. Franklin is going to ultimately recommend a sentence of some sort. I don't know what it is. He'll tell me once we're going. Ms. Hall has a different recommendation from the state. I'll figure out what I think is the right sentence based on your situation and as big a picture as Mr. Franklin and Ms. Hall can draw for me about what's going on in your life and what has been going on. Mr. Franklin, I don't think this has been on a trial calendar or anything, so Mr. Brown has the ability to withdraw his plea if he is blindsided by the sentence. Is that correct?
That's my understanding, sir. Yes, sir.
Okay, so Mr. Brown, I will listen very carefully to what everyone says, and then hopefully you'll listen carefully to the sentence that I impose. If it is a higher sentence than what Mr. Franklin asked for on your behalf, so I'm making this up. Let's say Mr. Franklin says Mr. Brown should serve 1 year. And I say, you know what, based on everything, it's all these entering autos, there's a probation revocation. I think Mr. Brown should serve 2 years. You'll have a chance to talk with Mr. Franklin and say, all right, that's not really what I want, but I'll take it. Or to say, no, thank you. That's not what I want to do. And then you back out of the plea, and that doesn't get used against you. I don't hold it against you. If you end up going to trial, the jury doesn't hear, oh, but you know, Mr. Brown actually tried to plead guilty. None of that gets shared with anyone. So you get to talk with Mr. Franklin if I disagree with his sentence. I might go along with it, and I can go below it. And if I go below it, you also don't get to withdraw your plea. I don't know why you would. So Ms. Hall's going to put you under oath in just a moment. Once you're under oath, Mr. Brown, it's important that you answer all her questions and mine truthfully, okay?
Yes, ma'am.
If you have any questions of your own, let Mr. Franklin know so we can work through those.
Okay.
All right, Ms. Hall, when you're ready.
Thank you. Ms. Brown, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Give me a lawyer hand.
DeMarcus Brown. Oh,
Please
This is-
state your true, correct, and legal name.
DeMarcus Angelo Brown.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No,
Is there any medication that you normally take that you have not been given today?
no.
How old are you and how far have you gone in school?
I'm 35 years old and I have my GD.
You 34 or 35?
35.
35.
Are you able to read, write, and understand the English language?
Yes,
Do you understand that you've been charged with 10 counts of entering an automobile, 1 count of theft by taking, 2 counts of criminal trespass, and 1 count of criminal damage to property?
yes,
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes.
Have you had enough time to speak with your attorney, Mr. Franklin, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Do you need more time to discuss this case with your attorney?
No,
Are you satisfied with his services?
yes,
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, of any for purposes of this plea.
And Mr. Franklin, do you waive any issues that might arise from proceeding off a copy of the indictment?
So waived.
Ms. Brown, have you been arrested on these charges?
yes,
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
no,
No, ma'am.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
yes,
The minimum and maximum sentence for entering an automobile is 1 to 5 years to serve. Minimum and maximum for theft by taking felony is 1 to 10 years to serve. The minimum and maximum for criminal damage to property is 1 to 5 years to serve. And the 2 counts of criminal trespass are 1 day to 12 months to serve.
yes,
Do you understand that this, I'm sorry. Do you understand that this is a guilty plea, which is also called a blind plea, is non-negotiated plea? The state can still make a recommendation to the court.
yes,
Have your attorney discussed our offer with you?
yes,
The state's offer for 10 counts of in an automobile is 5 to serve 3, balance on probation. The state's offer for the theft by taking felony is also 5 to serve 3, balance on probation, as well as the criminal damage to property. And then the 2 counts of criminal trespass, 12 months probation. Do you understand?
yes,
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
yes,
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
yes,
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
yes,
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
yes,
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
yes,
Do you understand that you're not allowed to possess or use a firearm while on probation?
yes,
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is
Yes.
true regardless of any advice by your attorney or anyone else.
yes,
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes,
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
yes,
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
How do you plead to the 10 counts of entering an automobile, 1 count of theft by taking, 2 counts of criminal trespass, and 1 count of criminal damage to property in indictment number 20-SC-176900?
Guilty.
Is this guilty plea freely or voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Mr. Brown. Your Honor, the state is aware of 8 prior convictions by the defendant.
I have the
Okay.
non-complex, the repeat offender notice.
Yes.
Is that, you got that same information?
And the 17 SC, the one ending in 934, that case has 6 years, 3 months, and 25 days remaining.
Okay.
And Your Honor, this case had several incident locations, so I'm gonna try to summarize everything.
It sounds like it's all the same day, but maybe different locations?
The 6th through the 9th of May.
Okay, not all on May 8th. There's a lot that happened on May 8th.
Right.
Okay, you're right, different days.
Had this case proceed to trial, the state would have proven that, or expected the evidence to prove that on May the 6th, at 5370 Old National Highway, and that's in Fulton County, the defendant and an unknown defendant to the state at this moment entered the property of Frank's Auto Repair, where they were seen on surveillance. Well, the defendant was seen on surveillance pulling the handles of vehicles, eventually getting into our victim's GMC Envoy, at which point the co-defendant of this case was the driver. The defendant was the passenger. There was a report that the vehicle was seen on May the 8th at another burglary, at another auto shop burglary. That location was 5548 Old National Highway. There was no damages to the first location, Your Honor, but the second location, there were at least 7 vehicles that windows were busted out. And at this point, we haven't confirmed all of the things that were stolen out of those vehicles, but there were a few vehicles where there were no damages. They're still in the indictment, but there were no damages or anything taken from those vehicles.
So they were entered, you can tell from surveillance footage, or
No.
because something was taken?
The second location, the officer could just tell that the cars had been rummaged through.
Okay.
For the cars that weren't damaged, but then there were 7 vehicles that had damaged windows.
Okay.
Officers spotted the vehicle at a residence. At that residence, there were 2 individuals that were approaching or leaving that vehicle.
And when we say vehicle, this is this GMC taken from on the 6th?
Yes, Your Honor.
Okay.
They spotted that stolen vehicle. The 2 individuals that were detained, they gave a name of a JT, which was the person that was with the defendant on the 6th. When officers of that investigation, the May the 8th investigation, went back to the Frank's Auto Repair for May the 6th, they looked at the auto, the surveillance, and that owner said that he believed that the defendant was DeMarcus Brown, known to be someone that is frequent that area and known to be homeless. Once that name was given, officers made contact with Brown. They did Mirandize him. He did admit to being the person on the video of the first incident. I believe that's all, Your Honor.
What connects Mr. Brown to the May 8th activities? Is there surveillance where people identified him? Is it fingerprints, or is it just this GMC Envoy was seen there?
It was Sorry, Your Honor. I tried to sentence this. I didn't write that down. Give me 1 second, Your Honor.
While you're looking that up, I'll ask Ms. Crawford. Good morning, Ms. Crawford.
Good morning, Judge McBurney.
Is the only open, it looks like all of Mr. Brown's prior felonies were from Fulton County. Is the only open one the 17 SC case?
Yes, Judge, that's the only case that he has open.
Thank you.
You're welcome.
And my apologies, Your Honor. I have about 4 or 5 different reports. It may take just more than a second.
Take your time. It's good. We're gonna go off the record for a minute. Ms. Snyder, are you still in here? Ms. Reed is not well.
She actually was released last night and is in court.
Okay, I thought I saw her just walk in. Okay, you doing okay? Okay, great. We'll get to you soon. I just wanted to, because we had taken her off the calendar based on information you had, but here she is. Okay.
Mm-hmm. She was happy as yesterday.
I just woke up. I was just
Your Honor.
You ready?
Yeah, I didn't find it because I remember the defendant was arrested on the property of one of the auto repairs on the 8th.
On the 8th.
Yes.
Okay, he was on the scene.
Yes, Your Honor.
Got it. Okay. All right. Mr. Franklin.
Thank you, Judge. I'll begin by stating that the ball on the request that we are making got to rolling prior to my meeting Mr. Brown. The attorney who had his case before me, Mr. Renard Nobles in my office, had some conversations with Mr. Brown. My social worker team met with him. And by the time I got to meet him, he had already been accepted into A Better Way Ministries.
Okay.
So I think the court is probably familiar with that program. I think it's one of the
That's the one in Sonoya?
Yes.
Correct.
Yeah. And after speaking with Mr. Brown, understanding the length of his record, I elected to go ahead and proceed with that request instead of looking into behavioral health court or drug court, just because I think he would benefit from the fact of not being in the metro area where there's certainly a lot of distraction and temptation, which his record would suggest he doesn't respond well to, at least not at this point.
Mm-hmm.
He has been diagnosed as schizoaffective. He takes Seroquel and Zoloft for that. However, I believe at the time of these incidents that he was off of his medication. I think he had been off since about the early part of 2019, and that he had essentially began self-medicating with cocaine. So we have two negatives that are kind of interfering with Mr. Brown's thought process at this point in time. Our request of the court is a sentence of 5 to serve 1, with the 1 year being the 1 year being reduced to time served upon his entry and completion into A Better Way Ministries. He has been in custody at this point about 328 days, thereabout.
Basically, May
Almost a
8th,
year.
May 8th, he was arrested. He's not been out yet.
Correct.
Okay, so we're a month away from a year.
Yes.
Okay.
He what was I going to say? He is desiring the program, which I always think is a really good indication of someone's potential success in the program. Within 2 minutes of us meeting, this is what he was talking about. So we actually had,
Because he had learned about it from Mr. Nobles?
yes, sir.
Okay.
And so we think that, trying to be solution oriented in response and not just punitive. We think that this is the best resolution for all parties involved. And I think that normally we would also make some consideration of restitution or something like that. But I think given his current status and his inability to pay, it's not an area that we will be able to bridge. So,
Okay, I want to follow up on that a little bit, but that reminded me of something I meant to ask you, Ms. Hall. Are there any victim impact statements or any restitution that you're in a position right now to advocate for?
No victim impact statements, Your Honor. I have spoken with 6 of the 11 victims. We have had to do investigative requests on the last remaining victims. So no, I don't have any accurate or precise numbers for restitution. And I wasn't going to ask for restitution here precisely as to what counsel said. I did want to put on the record, though, that there was a clear amount over $500 for all those vehicles. I did want a chance to speak with the rest, just to, let them know what was going on in this case and how we resolved it. But
Sure.
As far as the restitution, I haven't been able to lay my hands on all of the numbers.
Okay, well, and you're always free to petition to amend or modify the sentence, but to Mr. Franklin's point, and I'm sure you help the victims understand this, I don't think it's a situation where restitution would be forthcoming. That's not going to make them feel better, but at least we're being upfront with them about the realities of the situation. Okay, thank
if
you.
I may add one more thing, Your Honor. Ms. Jackie Patterson from my office, she's on the call.
I saw the name.
If the court needed more information specifically about A Better Way Ministry, she's here to provide it.
Okay.
She has spoken to personnel there, and correct me if I'm wrong, Ms. Patterson, I think we have transport available as early as the 12th of this month.
That is correct. Good morning, Your Honor.
Good morning. So a couple questions. One, I am familiar with Better Way Ministries. I'm not familiar with their capacity to work with someone like Mr. Brown, who ought to be on medication so that he's in a position to meaningfully participate in the program. What do you know about Better Way's ability to enforce a medication regimen, and maybe more importantly, to make sure that the medication is made available to Mr. Brown?
Sorry. Actually, prior to you coming to the bench this morning, I actually called over to confirm medication. He's actually not on any mental health medication at the jail. So he's taking medical medication, but he is not. And that was confirmed with both the pharmacy as well as the mental health department. So they wouldn't provide any medication that he's not, he's not on any mental health medication. Speaking to A Better Way's ability, they work to aid individuals. Actually, if you take a look at their website, it is a part of their mission statement. A part of it, they work with individuals through counseling so that they can become mentally sound, emotionally balanced. So I do believe that they would be able to accommodate Mr. Brown in that manner.
Okay. Other question I have is your sense, and I know you don't have a crystal ball on this, Ms. Patterson, but if Mr. Brown's sentence was to serve a year rather than reduced to time served, in other words, he would stay at Rice Street through May 6th, May 7th, what is the likelihood that he could then still join Better Way Ministries? Do they have a bed opening up only once a year, or is it your sense that fairly soon after he served the year that might be appropriate, given this being his 9th felony, that he would still be on a pretty short list to get into Better Way Ministries?
I believe you would still be able to. Actually, I reached out to them around mid-March, I believe it is, just to confirm his previous acceptance. They were willing to take him then. I confirmed again yesterday, and they gave me the date of April 12th. So I do not foresee any challenges with bed availability.
Okay.
I believe, Your Honor, when Ms. Patterson, we emailed back and forth about this in mid-March. She made mention, I think, that they typically have space for about 120 gentlemen, and they had about 80 at that point in time.
So there's room at the end.
I believe there would be room at the end.
Okay. I didn't realize it could be that big. That's fantastic. Okay. Got it. Thank you, Ms. Patterson.
Yes, sir.
Mr. Brown, tell me what you know about Better Way Ministries.
I really bucketed. I know it's pretty much on the basis, and
Take your time.
my it's like me. I mean, I've been doing drugs since I was 20. You know what I'm saying? And not saying that takes up for the reason I'm doing these crimes or anything like that. But it has a little bit to do, you know what I'm saying? I'm not ready to get the money and then me have to try and get the self-medicate and stuff like that. But like me, I've been wanting somewhere, but I've been in program, I've been in a couple programs in the Metro Atlanta area. But like you said, if I can get what my mindset, if I know that I've been here all my life. I know everywhere, and I'm gonna go find somewhere if the program's here. Sonoy, Georgia, I don't know nothing about Peachtree City. I ain't never been there.
Yeah,
You know,
I'll tell you, Better Way is in the middle of nowhere. You are not going to walk off that campus and say, hey, I know where I am.
Mhm.
So that's probably pretty good. What are you hoping? What's your number one hope of how Better Way will help you?
I'm real hoping to really get through with this program. Get back into myself and my higher being. Get back into my kids because I haven't had contact with them. I haven't had contact with my baby mama and get into my family. Like
How many kids do you have?
I have 4.
How young is your youngest kid?
My youngest is 8,
And how old is the oldest?
18.
18. Okay. So your thought would be when you're done with Better Way, you come back to Atlanta?
Well, my baby mom stayed, the one I got now, she stays in Roswell.
Okay.
You know what I'm saying? We've been together off and on, you know what I'm saying? But it's never nothing that we break off because I just don't come back home and then I just stay in the streets and everything like that. And I talked to her and she more willing than anything. And she just really want me off the drugs too and stuff like that. You know what I'm saying?
Yep.
And I want myself off the drugs. I want to be a better father to my kids and a better role model to my kids and everything like that.
Okay. Anything else you want to add?
No, sir.
Is this the longest you've been stuck at Rice Street, or have you been there longer than this time?
My longest was last time you had me when you sent me to another program, I think Group Point.
And you were in jail longer before you went to the program?
17 months.
17 months. And that was this 17 SC case? The one that you're on probation
No, that was
for?
the 14.
14 SC case.
I stayed 14.
The robbery case?
Yes. That
1, 2, 9, 4, 4, 7. That was with Judge Shub.
yeah.
So you were supposed to be working with Viewpoint for, said 8 years. That time wouldn't be up yet. Did you do some work with Viewpoint?
Viewpoint in the middle of Lakewood. Where they put me was in the middle of Lakewood.
Okay, not a great environment for you.
No.
Well, at least you know yourself, Mr. Brown. That's a start, I'll tell you. I meet folks who swear up and down, they're good, don't worry about it, just send them back home. And you're saying, don't send me to Lakewood because you know what'll happen there.
Don't send me no. Me, Atlanta. I grew up right down the street, Imperial Homes on State everywhere. You know what I'm saying? And I know everybody Atlanta is not a great environment for me. People, placing things, that's one of the first.
I got it. You sound like you went through drug court. You need to be thoughtful about the people you're around and the places you go. And hopefully Better Way will address that. All right, Mr. Brown, I find there is a factual basis for your plea. And I also find that your plea is knowing and voluntary. Knowing means that you have understood all the things we talked about. And if you didn't, you nudge Mr. Franklin and had him explain. Do you have any questions about anything we've talked about?
No, sir.
A voluntary plea just means no one's forcing you to do this, that you've decided, and I've already heard you say it, you want to go forward, you want to get to Better Way Ministries. Is that correct?
Yes.
Okay. Then I'm going to accept your plea. I'm sentencing you pursuant to the Probation Options Management Act, which means while you're on probation, if you have a technical violation, you miss a meeting or you test positive 1 or 2 times, you and probation will work it out.
Okay.
If it is more serious than that, you get arrested again, or you get kicked out of Better Way Ministries, that comes back to me, and we'll figure out what we're going to do as a result of that.
Yes.
So, Mr. Brown, I very much understand the state's recommendation. I can understand why members of our community, yours and mine, would be kind of fed up and frustrated. Here we are. This is your 9th felony conviction. You broke into a whole bunch of cars. And one approach would be to say, well, let's just lock this guy up. And that might bring some measure of relief to folks who were victimized by what you did. But then you'd get out and you'd be back in Atlanta and you wouldn't have gotten any help. And I don't know that we would have really fixed the situation. My hope is that Better Way Ministries is a step in that direction. But if I'm wrong, there'll be a way to get you into another form of treatment. It just might be treatment where the doors are all locked from the outside that you don't get to walk away from. So I'm going to sentence you on count 2 to 8 years to serve 1 year with the balance on probation.
Okay.
It will be a special condition of your probation that you enter into and complete the Better Way Ministries program. So you got to get all the way through. You got to graduate from that. Mr. Franklin, how do we need to structure this so that Mr. Brown isn't released to the streets?
Yeah,
I'm wondering if what I ought to do
it's hold
is
it until
till May 8th and sign the sentence.
my first reaction is the same thing, that you pronounce sentence today and we know that the case is essentially done, but wait to file the sentence.
Yep.
Until just before, I would say about a week or a week and a half before that date runs out. And
I think what I'll do to be safer is I will do that, but I'm going to change the sentence, Mr. Brown, to 9 years to serve 2 years, but I'm going to reduce those 2 years to time served. But you should know I'm not signing your sentence until your 1 year anniversary at Rice Street.
Okay.
So on May 8th, 2021, I'll sign your sentence. And then Ms. Patterson and Mr. Franklin can figure out when can transportation be arranged, when is a bed open. Sounds like beds are open now and will remain open. We're only talking about a month. It's a month and 2 days from today. But then you will have served a year, which I think is a minimum you ought to serve for what you got mixed up in again. But then we'll get you to treatment in the form of Better Way Ministries. So that's 9 years to serve 2 years. The 2 years are reduced to time served upon your entry into the Better Way Ministries. And then it's a special condition of that probation that you complete the Better Way Ministries program.
Okay.
When you're done, you're thinking home for you might be up in Roswell. All right, it'll be a condition of your probation that you stay off of Old National Highway. That seemed to be a problem location for you. So while you're on probation, you can't be on Old National Highway.
Yes, sir.
And the third special condition of probation is that you need to submit to a mental health evaluation.
Okay.
And if there's any treatment recommended, which could be prescriptions for Seroquel or Zoloft, if a doctor says, hey, this is going to make you more stable and in a better position to be a participant in your family, hold down a job, you'll need to follow that doctor's recommendation and take that medication. Okay? Your sentences in counts 1, 2, 4, 6 through 12, and I guess 13. So 1, gotta say that again. Sorry, Ms. Nelson. 1, 3, 4, and 6 through 13. 1, 3, 4, and 6 through 13 are 5 years to serve 2 years. Those 2 years will be reduced to time served upon your entry into Better Way Ministry, balanced probated. Those will all run concurrently with each other and with count 2. And finally, counts 5 and 14 are 12 months to serve. Those are the misdemeanors. So the overall sentence is 9 years to serve 2 years, but those 2 years will be reduced to time served about a month from now when you get out and go to Better Way Ministries.
Okay.
You'll be on probation for 7 years. That is longer than I usually put folks on probation, because if things don't go well and you are breaking into cars again or something like that, I will likely, if it is proven that you did those things, revoke a whole bunch of that time and say, you know what, Mr. Franklin and Ms. Patterson and you committed to Better Way. This is going to be different for me, Judge. I'm 35. I'm trying to put this behind me. If that doesn't work, then we just got to take you out of commission for a while and see if that works. I don't think it will, but I'm sort of out of options.
Yes, sir.
It doesn't get a lot better than Better Way Ministries.
Yes,
That's sort of how you need to think about it, is that that's your chance.
Yes, sir.
I think I checked everything. We've got the revocation to work through, but I'll have that sort of dovetail with this. Ms. Hall, did you have any other conditions of probation you wanted to see? Okay. Before we work through the revocation, Mr. Brown, you should talk with Mr. Franklin real briefly, because this sentence is about a month longer in terms of time served. It's also longer with exposure on probation. And you've got the right to say no thanks and have a trial instead. So talk with Mr. Franklin about that.
Basically, we asked him to see if he able to go to Better Way Ministries. He wants you to do this for a year.
Ms. Nelson, did I make it clear enough what the sentence is supposed to be?
Yes, sir.
All right, thank you.
Mm-hmm.
So, Mr. Brown, did you get a chance to speak with
Yes.
Mr. Franklin?
Yes.
And do you want to go forward with this plea, or do you want to withdraw the plea?
I'll go forward.
Okay. Then 2 last things. This is a copy of your indictment. Normally, you'd sign it, Mr. Franklin would sign it, Ms. Hall, but we're trying to hand paper around less. Do you authorize me to sign your indictment indicating your plea of guilty?
Yes.
Mr. Franklin
Yes, Sean.
and Ms. Hall?
Yes, Sean.
All right, last thing then. You have an open probation case, 17 SC 154394, and you violated probation by getting arrested for these new charges and now pleading guilty to it. I'm prepared to handle the revocation now, Mr. Franklin. If I'm not aware of there being a petition. There may be, but I didn't see it. If you're willing to waive.
Petition, but we expected to handle it today.
Okay, so you're prepared to go forward?
Yes.
So, Mr. Brown, given your conviction in this case, the 20 SC case, I'm going to revoke 1 year of your probation in 17 SC 154394. You'll get credit for the time you served from May 8th, 2020 going forward, and then I will reinstate the balance. So you're actually going to have two cases that you're on probation. The one that has a longer term is this one that you just entered your plea for, but you only have to report to one probation officer.
Okay.
I will waive your probation supervision fees for the first 6 months after you get out and you finish the Better Way Ministries program. So you can.
Your Honor, it actually would be helpful if Mr. Whitenhour's case went first.
Sorry, what?
All right, thank you, Your Honor.
Oh, she's in another courtroom.
Okay, Ms. Sims? I don't know who Ms. Sims is.
She is the sex crimes prosecutor taking Ms. Basis' place, I believe.
Okay,
She's covering for me.
all right. Anyway, back to your case, Mr. Brown. I'll waive your probation supervision fees for the first 6 months. Do you need to get contact information?
Yes, Judge, I just need to get an address from him, just an address.
Okay. Do you have an address where you would be living when you are no longer in custody?
Yes, I don't have my own girlfriend address.
Can you say that again?
Yeah, I can't remember her address, but I do have my brother's address, and y'all can get, when I can get in touch with him, y'all can get in touch with him to tell me my girlfriend's address.
You give me your brother's number, I'll call him.
Okay. 44 668 9609.
Okay, what's his name?
Dante Brown.
Okay. I'll call when we have a break.
So I just didn't follow, Mr. Brown. You're going to call
His brother to provide the address that where he at least will be able to go to when he's finished with a Better Way Ministries.
Got it.
If they need an address for a Better Way Ministries, I have that available.
So, Ms. Crawford. No, go ahead, Ms. Crawford.
I'm sorry. Mr. Franklin can just provide me that telephone number in the chat, and then I'll contact the brother and get a number, get the address.
Great.
Okay.
We'll do it that way. We'll get you the phone number. You'll reach out to Mr. Brown's brother and get an address. And I guess there's not really a report date for Mr. Brown because he'll be released to a program.
That's correct, Judge.
Okay. All right. I think that's it. Mr. Brown, I hope this works for you. 2 thumbs up from Mr. Brown. All right, that is a position 203. Before it's Mr. Morgan is next, but before you bring him out, I just need to chat with the lawyers. Is he back there? Okay, hold off on that. So, Ms. Snyder, I assume you've seen the filings that Mr. Morgan has made. Where is there an ex parte that has been filed that was dealt with? I don't know where we are in that.
Now, the last time we were in court, he had been offered BHTC, which he refused, and then wanted a trial. And then so we had set it down for a bond hearing. When I filed it in February, I mistakenly didn't change the indictment number, and so it was rejected, and I missed that email, but I filed it.
Oh, this is a re-indictment or?
This is a bond hearing today.
Okay, but you said something about an indictment. Does he have more than one case?
No, on my bond form, I mistakenly didn't change the indictment number from the case that was on the template, I guess.
Got it. And so when you filed it, it went into someone else's case.
They rejected it because it wasn't attached to them.
Okay. All right, so today you believe we are talking about bond. Is this a Ms. Hall case, or is this a Ms. Beza case, or what do you know, Ms. Hall?
Your Honor, this is Ms. Basil's case, and Ms. Sims, she's on the Zoom. She will be handling it.
Okay, and is she, there's Ms. Sims. Hello, Ms. Sims.
Yes, hello, good morning, Your Honor. And
Good morning.
for earlier, I didn't have my mute on.
That's okay. Were you aware we were going to be talking about bond for Mr. Morgan today?
No, I was not, Your Honor.
Okay. The only reason why I'm asking, Ms. Snyder, the calendar doesn't say bond. It says multiple filings by defendant, which is accurate. He's been filing lots of things. He's mad at the state for having made up all the charges. Let me look at one thing. So you have filed a motion for bond. I see that it was filed after the calendar was published.
Yes, so the calendar is what made me realize that my previous one I filed in February had been rejected.
Okay, all right, got it. So I can understand why Ms. Sims isn't in a position to pursue it. We can, I'll let Mr. Morgan know that. He sure won't be happy about it, but I need to make sure the state is in a position to have whoever it wants to have involved with the hearing. I did want to check one thing. Okay, so it's one victim, multiple counts because of allegedly different injuries to Mr. Hill. Okay.
It's one of their stereotypical charge one injury in 5 different ways type of thing.
I mean, they sound like different injuries. It's left hand, left leg, and face. It sounds like one incident. It's all one day and a knife. But I was trying to understand Mr. Morgan's, one of his recent filings about wanting to sue everyone because there's only one victim who's not a family member of his. So we'll bring Mr. Morgan out in a minute, but your sense, Ms. Snyder, is that Mr. Morgan, should we agree to put him on a trial calendar, is he may not be willing to, but he is able to assist you in defending the case. Okay, got it. All right. So, Ms. Sims, we are not doing the bond hearing today because you didn't have notice of that. We're going to talk about needing to have a bond hearing the next time we can get Mr. Morgan over here. Although I noticed Ms. Snyder filed a waiver of his presence, and we'll talk with him about that as well. But if he doesn't need to be physically present, we might be able to get it set down on a Zoom calendar soon. Ms. Sims, how long will you be handling the domestic violence cases in this division?
Sometime until August, Your Honor.
Okay.
I don't know the exact date of her return.
Got it. But for a few months.
Yes.
Got it. Ms. Snyder, do you believe all the discovery in this case?
I believe so. The only thing I'm missing is good contact information for Mr. Hill. I believe he is residentially challenged.
Okay. Well, I'm sure Ms. Sims will be looking for that information too. Okay, I just wanted to get as much info as I could before we brought Mr. Morgan out. So if you all would please bring Mr. Morgan out, we'll see how this goes. Good morning, Mr. Morgan. How you doing? You've been better. Okay. Mr. Morgan, let me tell you what we're going to talk about this morning, and then we may be talking again pretty soon. I've been reading the things you've been filing. I've also been reading the things that your lawyer, Ms. Snyder, has been filing. I read what you file, but you need to understand that when you have a lawyer, your filings don't have legal effect. And let me just give you an example. You might file a motion to dismiss the indictment because of X and Y and Z. There's only one victim in the indictment, but there are multiple counts, or the victim wasn't a family member, things like that. I'm not saying that those are legally valid arguments, but you don't actually get to make those arguments. Your lawyer does that. So you and she should coordinate on that. I'm not ignoring your filings. I just can't actually respond to them because it's the lawyer who files things like that. Secondly, Ms. Snyder's filed a motion for bond in your case. We're not going to hear it today because the prosecution didn't have notice that today we were discussing it. They have the motion. Ms. Snyder filed it in the system and it went there. But our calendar actually was meant to address some of the things you've been filing. But we will hear the bond motion real soon, once the prosecution has a chance to give notice to Mr. Hill and they can be prepared. The third is, it sounds like your case is trial ready, meaning Ms. Snyder has all the evidence that the state has, and she feels that it's ready to go to trial. I know you are anxious to get this matter resolved. You've shared that view in some of the things you filed. And so I wanted to talk as a group, and the prosecutor's actually on the screen. Maybe Ms. Snyder can rotate the screen a little bit. It's Ms. Sims. You see a square that says Michelle Sims? That's the prosecutor in your case. And so I wanted to get input from your lawyer and from Ms. Sims about whether folks are ready for this to be put on a trial calendar, because we've started doing that again. And then we just need to figure out when to get you a bond hearing. And I think that's it. But I wanted to give you a chance to share with me anything that's been on your mind.
I can't hear him.
Okay, we're going to move the microphone a little closer to you. There you go.
It's like every time I come before this, the A isn't ready or somebody's not ready, but you know, I'm still sitting in jail. I've been in jail now 15 months. And it's like I'm trying to get this case resolved as soon as possible.
So you're ready for it to get to trial?
Yeah, I'm also ready to resolve this case today.
I'm sorry, Judge. Is there some way he can go to the podium?
Sure. Mr. Morgan, do you mind going up to the podium? It'll be easier for the court reporter to hear you. Thank you. All right. So you were saying one, you're frustrated because you've been to court a number of times and your sense is there's always someone who's not ready when you come to court. Two, you've been in jail for 15 months and you're ready to get this resolved. And then three, what you were saying that was new to me was that you were prepared to enter a plea today to a negotiated plea. My guess is, I don't know, but my guess is that Ms. Sims and Ms. Snyder haven't necessarily negotiated something, but they ought to talk if that's something you're willing to do. The things you've been filing didn't suggest that that was the route you were taking. You seem to be taking a different route. And so my thought is we do three things. One, we set this down for trial. So at least we have a date where we know whatever happens, we can resolve it then. It may get resolved before then with a plea, but at least we're getting a date out there that says Mr. Morgan comes to court and a jury decides once and for all what happened in this case. Again, you can sort it out before then, but that addresses your how long do I have to wait before I get closure. Number two, we need to have a bond hearing. Ms. Snyder has asked for that. It's not what's on the calendar for today, but there's no reason why we can't get you in here, or you could Zoom in. However we work that, you should talk with Ms. Snyder about that and get that bond hearing. And that would be well before the trial. But number three, it sounds like you and Ms. Snyder ought to talk a little bit so she's got a sense of what you think a reasonable outcome is if you were entering a plea, because she needs to have a sense of what numbers you're thinking about to talk with Ms. Sims. Ms. Sims is going to have her perspective. These are serious allegations. Maybe it was self-defense. Maybe it didn't happen. I don't know anything about the case other than what it says in the indictment, which are purely charges, and you've got the presumption of innocence working in your favor. So it sounds like there ought to be some conversation between Ms. Snyder and Ms. Sims. The way we get all that rolling is by you and Ms. Snyder talking a little bit about where you think things ought to go. You're both here, and so my thought is you spend some time talking this morning. Are you willing to do that?
Yes, sir.
Okay. Are there things you want to add, or do you feel like those are talking about the plea, getting you a bond hearing, and then as the fail-safe, let's get that trial date because everything has to resolve by then. If you haven't played it out, then it goes to a jury, and they decide what really happened on that date with you and Mr. Hill. Did something happen? Did nothing happen? Who knows? The jury will hear about it. They decide. Does that work?
Yeah.
Okay.
So I speak with Ms. Snyder for a while.
I don't mean to commit her to it, but are you willing to spend some time talking with Mr. Morgan about those three things? I mean, you've already done what you can do on the bond side. You filed the motion. We need to get it on the calendar so the state has notice. You can talk to him about trial, as you were sharing with me. And then the part that's newest to me about this is maybe it's something that would work out. And I just don't want to miss the opportunity because I know it's hard to connect with Mr. Morgan at the jail, and here you all are. All right. So, Mr. Morgan, I'm going to ask Ms. Snyder to speak with you. I think she's got one other case on the calendar. We're going to do that one next so that then she can spend time with you and not be worrying about her other matter. So if you'd sit tight, we'll get her with you and you guys can talk. And it may be that we need to talk one more time today before you go back so I can get an update from you and Ms. Snyder. Okay? All right. Thank you, sir. So, Ms. Reed, we're going to handle your situation right now. Am I correct? That's your only other case on the calendar? Okay. And all we were doing today was figuring out if Ms. Reed had completed PTI.
She has not completed her hours yet due to some medical reasons. And if we could approach, I don't want to put her business out there.
You don't need to put it out there. If you've talked with Ms. Hall about it and Ms. Hall is agreeing that there ought to be, I'll look it up. I don't know if there was a deadline or.
There was. It was a deadline of March from November. She's essentially been homebound by her doctor.
Okay.
So we're trying to.
She's not homebound right now. I hope it's safe for all of us that she's here.
It's just difficult for her.
Okay.
To be out.
Okay. And the hours that she needs to do are hours where she'd need to be out and about.
Right, we're just trying to find something that she could do that's sedentary or virtual. We just, through the pandemic, have struggled finding
Okay.
that.
I'm just looking at, so, okay, it's community service and it needs to be documented. So maybe there's something at a church or a community center where she could be seated and not necessarily having to lift heavy objects and run and things like that.
I'm hoping with the vaccines and we'll opening back up a little bit more, we'll be able to get her in somewhere.
Okay. Have any hours been done, or we've got the full 50 that still need to be done? Okay.
I didn't use license, I was in that's what I'm sitting out there for 3 weeks, scheduled services. So I haven't done it.
Okay. So Ms. Hall, has Ms. Snyder shared some of this information with you, or is this news to you today?
No, Your Honor, she's shared all the information with me.
Okay. Are you comfortable extending the deadline? The deadline was March 11th, it's April now, but pushing it out X months to give Ms. Reed an opportunity to line something up?
Yes, Your Honor.
Okay. What do you think, Ms. Snyder, is a reasonable window?
She's set to have her knee surgery in about a month or so. And I just want to make sure that she has some time to
recover
before we send her back out into the world.
Yeah. So what if we said, like we check in September?
Okay.
Does that work?
Yes, sir.
Okay. I assume Ms. Reed is anxious to get this out of the way.
If she completes it prior to that, we'll get the documents to Ms. Hall and the order to Your Honor.
All right. So what we'll do is reset this to early September. And certainly if it gets taken care of in July or August, because Ms. Reed is able to do it, then get that to Ms. Hall and then she can file the dismissal. But that ought to give you some time, Ms. Reed, not only to have the surgery, but then to recuperate, because we don't want you to aggravate things by getting active too soon after the surgery. Okay. All right. Thanks for coming. All right. So can Ms. Snyder spend time with Mr. Morgan, or not while we have someone else out here? There's just two of you.
And then Mr. Morgan and I have had that conversation. I just haven't had a chance to relay that the new information to Ms. Sims.
Okay. I'd still like you to connect with him, but let's figure out maybe if we're doing, I jumped around. So Mr. Daniels is next, but I guess he's in custody. Mr. Franklin, do you have anyone who is in the gallery that you want to handle?
Not aware of.
Okay.
Terrell Brown is here. Okay. Terrell Brown doesn't be my client. I haven't spoken to him.
Okay.
He, of course, he's doing fine.
Yeah. Oh, it's plea and arraignment, so that'll be quick. We can. I just was wondering if it was something that would take a little while and it was out here, then we could have.
I saw a name on the screen earlier, Eugene Holder. I know that he has a blue square up on the screen now. He was represented at some point in time by a non-complex attorney in my office. The allegations were said to be.
Ms. Mormon is on the call. She was hired yesterday.
Okay, so if that's his attorney, then that won't be my case.
Okay.
I have Janae Shine. She's the fiance of Randy Manuel. We're addressing the FTA and bond.
Okay. All right. Well, why don't we do Mr. Holder next, so we can get him and Ms. Mormon off the call, and then we'll get back to, I guess, Mr. Daniels. We'll just go back to the regular schedule. All right. Mr. Holder, if you could join us, and Ms. Mormon, if you could join us, please.
Good morning, Judge.
Good morning. There's Ms. Mormon. All right, Mr. Holder, there he is. All right. So Mr. Holder, this is your plea and arraignment date. You're charged with 2 counts of theft by taking. Ms. Hall, do you know why this got kicked to us from non-complex? Is it repeat offender or is it's supposedly complex?
It's supposedly complex. Over $100,000 worth of gasoline was allegedly stolen.
Oh, that's a lot of gasoline.
In my case, or white collar.
Okay. I'm just looking the case up. There's the order of transfer. Oh, that's a pretty detailed order of transfer. All right, fair enough. So, Ms. Mormon, good morning.
Good morning, Judge.
Is Mr. Holder wanting to be formally arraigned or is he waiving arraignment?
No, Your Honor, we can waive arraignment.
Okay. I will have, if you don't already have it, I'll have Ms. Nelson email you our waiver of arraignment form. If you fill that out and get it e-filed, that will get us moving along. We will enter a scheduling order that will give the state a deadline to get you the discovery, Ms. Mormon, and then you'll have a deadline for filing motions, and that'll be the trigger for us to know, well, we need to set down a hearing for an evidentiary motion. If you don't file any motions, then we know we can put the case on a trial calendar.
Okay.
All right. Anything else you need to share with me about Mr. Holder's situation?
No, Your Honor.
All right, Mr. Holder, you are on bond. I don't know all the conditions of your bond, but make sure you continue to comply with those. Did you get something in the mail today telling you about the hearing?
I did.
Good. I've got an address for you on Delow Drive. Do you still live on Delow Drive?
Correct. Yes, sir.
Good. All right. So you'll get stuff in the mail telling you when you need to come to court again. Ms. Mormon will also be keeping in touch with you. If you move for any reason, make sure you let Ms. Mormon know so we can get your address updated, okay?
Okay.
All right. Ms. Hall, anything else on behalf of this case?
Nothing further from the state, Your Honor.
You mentioned it might be a white collar case. Are we going to run into some discovery issue because it's not yours, it's white collars?
No, we won't. I've been talking with Ms. Ingram already about the case, so we'll both figure it out.
Excellent. Sounds good. All right. Thank you, Ms. Mormon, for joining us. You and Mr. Holder are free to go. We'll look for that waiver of arraignment form, okay?
Thank you, Your Honor.
Okay. Thank you, Your Honor.
Bye. Is Ms. Snyder back? All right. Let's leave her back there for a second. So, Mr. Franklin, you've got Mr. Daniels, and that may just be an arraignment?
I need to get you to sign the ex parte.
Okay.
On that one.
Got it. So you don't want to handle arraignment. You want to have us figure out the situation before we do anything else?
Yes, sir.
Okay.
I accepted the visit at the jail yesterday. He didn't see me. He didn't come out, so I'm trying to talk to him today.
Okay. Got it. Jawanza Mathis. Is that going to be your case, Mr. Franklin?
No, sir.
No, Judge, that's Ms. Patel's case, and that one has been reset to April 19th. Ms.
Okay.
Patel is on leave today.
Got it. Reset 19 April. Thank you. And then Sonia Stevens, you were hoping would come in.
I was hoping she would come in. We had a virtual freestyle agreement. This was negotiated before Ms. Sam, before Ms. Besa. Took us to a program. You recall this is one where my social worker and I personally drove her to the program. The hope was that she would complete it, and then at this point in time, the case would be dismissed.
Yeah.
She was terminated from the program.
Ooh.
And she was struggling with housing at the time we were dealing with my social worker and I had tried to put her in a hotel with our own money at some point in time.
Yeah.
And eventually we weren't able to continue doing that. And I've just not been able to have contact with her or find me contact with her.
Okay, so Ms. Sims, there are two other cases. Are you handling all three of the cases, Ms. Sims?
I'm aware that this case is mine. I'm not sure of the other two. I haven't received notice on those. If they involve the same individuals, then they would be mine as well.
Okay, the only one on the calendar is this one, the one I'm asking about. I'm just looking. The other, it's a family violence battery. It's governed by the same PTI, virtual PTI order.
Okay.
So my guess is it's yours also. I don't know if it's the same victim, but.
All right.
For all the cases involving the same gentleman, father of the children.
Okay.
And I think the reason we got to a virtual PTI because he also had several cases that she.
Right, I'm remembering now about Ms. Stevens, but she was terminated from Solomon's Temple. She's not here now. So it seems like these ought to come off the dead docket, be reactivated. And Ms. Nelson, is this a notice calendar?
Yes, Judge.
Okay. Then it seems like a bench warrant is appropriate. As always, Mr. Franklin, if you or your team make contact with Ms. Stevens and bring her on in, we can handle the bench warrant in a different way. But for now, it seems like we've lost contact with her, and the program and treatment that was meant to address some of this ended up unsuccessful.
The one request I would make is kind of unusual. If we could hold off on it for like 2 or 3 days, just for me to have the possibility of having a conversation with Sims. But flatly, I have some begging to do, but I think that under the circumstances, it may warrant another outcome.
That's perfectly reasonable. They need to file something anyway to get it off the dead docket. So Ms. Sims controls this. Right now, the 3 cases are inactive. It seems like they should become active again, but that would be at the state's initiative, not mine. I'm not ordering her to do it. So, Ms. Sims, Mr. Franklin's going to be reaching out to you. It sounds like maybe on bended knee to talk about the 3 cases. And then it's really up to you. If you think that they should be reactivated, that seems appropriate, but that's a decision at the discretion of the district attorney's office. And I'll stay out of it.
All right. Thank you, Your Honor.
All right. Thank you. So, then we've got Mr. Brown, which is a plea and arraignment, position 9.
Yes, Your Honor. I filed my motion for discovery yesterday. So I was going to get that, as soon as the talk get together for me. I'm filling out a waiver of arraignment as we speak.
Is Mr. Brown here?
Yes.
He's right there. Great. Good morning, Mr. Brown. I'm Judge McBurney. Your case has been assigned to my division. Mr. Franklin is your lawyer, and he's just filling out some paperwork so we can get things moving. There'll be a scheduling order filed, and that'll obligate the prosecutor, who's Ms. Hall, right there, to get all the discovery in the case, police reports, anything else they've got to Mr. Franklin, so that you and he can talk about what are we going to do with this case. It doesn't, from the charges, sound like a real complicated case, but that doesn't mean there wasn't something strange that happened where maybe the police didn't do things the way they should have, and that's what Mr. Franklin will be looking at. And we'll get you back in court either to hear any motion that Mr. Franklin may have, or to see if the case is working out. I want to make sure we've got good info on you. You've got some old cases out there. All right. So, Mr. Brown, I've got an address on Dolphin Drive. Is that still a good place for you? Apartment 2? All right. You'll get stuff in the mail telling you when you need to be back here. Mr. Franklin will also be reaching out to you. Don't lose that card. All right. Do you need him to stick around? You're going to talk to him? Great. If you give me the waiver, we'll get it filed. Thank you. Okay. So you're free to go if Mr. Franklin says you can go, okay? So I think all we've got left then is Mr. Daniels. But Mr. Daniels, do you want him to come out or you want to talk to him?
I want to talk.
Okay. But if you'll get me that paperwork, that'll be helpful. And then Mr. Manuel. So we don't need to see Mr. Daniels, but I'll get your paperwork. And I may do it now so you can leave with it. Otherwise you have to come back. And we'll handle Mr. Manuel. So I'm going to work on your paperwork while Ms. Snyder's still back there. Then we may need to pull her out because Mr. Manuel's all that's left. Here you go, Mr. Franklin.
Thank you, man.
Bet.
Yeah, that's what I have.
I really want to. Oh, I mean, what's, no. This is like.
Perfect timing. Ms. Snyder, do we need to bring your client back out here, or are we in a good spot? Okay, so you'll talk with Ms. Sims. Great. What about, am I free to put Mr. Morgan's case on the next available consolidated jury trial calendar is the week of May 3rd. It's a 2-week calendar, week of the 3rd and the 10th. Can I submit this, or is that?
I don't think that'll problem. I think in Odyssey, it already shows he's going to be on the June trial calendar.
But those are placeholder calendars. Ms. Nelson needs a place to put things when we agree, hey, this murder case isn't pleading out. There's no other place to put it, so we don't lose track. Someday we'll have trials in here, but not immediately. And so the only way to try our cases is to get in that consolidated calendar, like Judge Cox did with the one you have. And we've got one on there. Dante Hudson has a co-defendant in a 3-defendant murder. That's ours on there. But you're okay with me adding Mr. Morgan to the May 3rd calendar?
Yeah.
Okay. All right. It's not a particularly old case, but it's old enough that it'll probably be in the middle of the pack. That is the first calendar that is opened up to sex crimes cases, despite Judge Cox having put one on the calendar that starts in a couple of weeks. That wasn't supposed to happen. But so that calendar may be a little bigger because there are a number of judges who have said, the only thing I have that really fits the criteria of one defendant and kind of old is a rape case, because my murder case has 2 defendants or 3 defendants. So, all right, great. Then we'll let Mr. Morgan go. Do we need to bring him back soon for a bond hearing? Or do you want to reach out to Ms. Nelson on that?
Yes, and I did explain to him that if he continues to want to hold his presence, it would be much easier to have it done between his 2 people.
Right.
So I will speak with Ms. Sims this afternoon and let Ms. Nelson know.
Great. So I'm going to leave the bond thing in your court. You'll talk with Ms. Sims, then you'll talk with Ms. Nelson. It may be we see Mr. Morgan soon for a bond hearing, or we don't need to see him because he's agreed to waive it. Maybe we see him soon because it's working out. And it may be that we see everyone on the 2-week calendar on May 3rd. Okay. Mr. Daniels, we took care of. So you should have Mr. Manuel back there. Are we ready for Mr. Manuel?
I am. I'm not positive.
Good question. Ms. Hall? This is our add-on calendar that was published on March 26th. Mr. Manuel is charged with aggravated sodomy, enticing a child.
Oh, yeah, that'll be Ms. Sarah Patel.
Okay.
She was on earlier. I just let her know that we're ready for the case. Or the course of the case.
Okay, there's a Michael Parrish on. Is that a colleague of Ms. Patel?
Sorry, Judge, I am your new sex crimes prosecutor. Let me see if I can get my camera working. There I am.
There he is.
How are you doing, Judge? Nice to meet you. I just wanted to observe a little bit of court. I don't think I have anything on your calendar today, but I just wanted to kind of get a feel for the way court runs. I'll be handling the adult sex crimes cases in your division moving forward.
So your timing is impeccable. Are you replacing Ms. Patel for the time being?
I am not.
No.
But the adult sex crimes cases that she was handling, I'll be taking those over. So if it's still an aggravated child molestation, that will still be Ms. Patel, or that will still be the crimes against children prosecutor. But if it is an adult victim and an adult defendant, then it would be my case. So a rape case or an aggravated sodomy case, those are going to be the ones for me, but featuring adults, if that makes sense.
It makes sense. Who used to do that in this division?
The name I have is to be announced number 2.
All right. Well, welcome aboard. I strongly encourage you to reach out to Ms. Nelson, my litigation manager. She needs to get your email address, your cell phone, all the kinds of ways where she can reach you to let you know what's going on. And it will help me. So as I understand it, the new administration has sliced and diced what used to be called CWAC into, it sounds like, 3 categories. There's adult sex crimes. Perpetrator is an adult, victim is an adult, and that's you.
Correct.
Then there are crimes, sex crimes against a child. Perpetrator is an adult. Victim is a minor.
Correct.
That's not you.
That is not me. And then the third category is going to be the domestic violence cases where there's some prior relationship between the two.
Okay, and that's Ms. Sims, and Ms. Sims was on this call. I don't know if she still is, but that's Ms. Sims. So the question I've got, since you're on this call, is who is handling the sex crimes against children for this division? Because we have a case with that falls into that category that is on today's calendar.
The name on my sheet, Judge, is Siri Patel, but I don't know if she has, I don't know if she's even, I know she is preparing to take leave. I don't know if that's happened yet and if someone is covering, but I can reach out to her. I can go back on mute and reach out and see if I can figure that out for you. Who's
right. No, I know she's leaving, but I was told by Ms. McCauley that would not be until the first part of May.
Okay.
Your Honor, Ms. Patel is still handling the case. She is currently in Millender's courtroom handling the case as we speak.
Millender's not even here.
She's not here, but she's currently in court at home on Zoom.
Oh, she's not at home either, but okay.
One of my colleagues is in court with her, and that's what she
did. Okay.
But Ms. Patel says she's literally in court right now handling the case in Millender. But she did ask if I can handle the case. It is a FTA request that we listen.
I'm happy to have you handle it, or to have Mr. Parrish handle it. However you guys want to slice it. We just need to
jump in to be clear that it is her case. She is just in another court.
Okay.
Right now.
During Judge Millender's break. All right. Well, let's bring Mr. Manuel out, and we'll figure out what we're going to do. Yes, ma'am. Thank you for speaking with your client. And your sense is that the name Carr, that Carr case is not going to be a trial?
So it is, the 15 case was re-indicted, so it has a 20 SC now, but I have been extended a very reasonable offer.
That'll make it go away. Okay. I'm not holding you to that. It's just helpful to know there have been a number of judges reaching out, like, why is this case on the calendar? It's not supposed to be on there. If it goes away, then it's not an issue. Well, but his time in jail is what matters. They can make it a 21 SC indictment. He's been in for 2,000 days. It'll be position 1. Okay. Thank you.
Thank you.
All right. You, Mr. Manuel? How you doing? Good. So, Mr. Franklin, we're on to sort out what should happen next with Mr. Manuel. This is an old case on 2 dimensions. It's an 18 SC indictment. I spent a little time looking at the docket before I came out here because it was odd to have an FTA this late in the process. It's actually 2015 alleged conduct. And Mr. Manuel at one point had a signature bond, a $25,000 signature bond that I think may have been partly a byproduct of the state not indicting. They eventually did. There was a warrant issued, grand jury warrant, but that's not surprising because it was a direct indictment 3 years after the fact. But then there was a different bond entered, and that was a surety bond. Eventually, he had Judge Downs entered a $25,000 signature bond in June of 2018, but then later it became an appearance bond. Anyway, I'm going to give you a chance. I just want to let you see what I've seen. 2019 was where this cash bond or bond through a bonding company came about. And that's the confusion to me, is how we went from a signature bond to a secured bond. And then nothing happened with the case for almost a year. And another warrant was issued in September of last year. That warrant caught up with Mr. Manuel. I saw the ticket and he got pulled over or something. And they ran his name, and lo and behold, he was wanted, and here he is. So I assume you want to back out. I'm a little confused as to why we keep losing track of him, other than the fact that the case just seems to get older and nothing happens. And so maybe he moves, or who knows. Your turn.
All right, thank you, Judge. So again, I want to acknowledge his fiancee, Janae Shine, who's present physically in court. His mother, his sister, and some other family members you can see on the screen, Vonda Manuel. Vonda is his sister, his mother is Gwendolyn. And for the purpose of my argument, Ms. Gwendolyn, you may want to hear from her in addition to Ms. Shine, because it's a missed court date for Mr. Manuel, but it kind of isn't a missed court date. So I think to answer the court's first question, he had the signature bond. He was arrested on a drug charge. That, of course, took the bond away.
Oh, when he had the signature bond, while out on the signature bond, got arrested for a drug case.
Correct.
Okay, what happened to that case?
He let it out before judge reheard.
Okay, while this was pending.
Correct.
Okay.
And I believe she granted another bond at that point in time. I think that would have been late 2019. That's what the calendar showing.
Mm-hmm.
Before that, Your Honor, Mr. Manuel had attended at least 9 court dates while out on bond. In July of last year, there was a missed court date, and I think I told the court I've always had great contact with him. He always comes to court. Ms. Shine is always with him. I think he even had a court date that he attended by Zoom, Your Honor, maybe in March of last year. So he's never had an issue coming to court or wanting to address the charges. Nevertheless, they changed addresses, but I think the July notice went to an old address and wasn't forwarded to their new address on Richardson Street. He had the September court date last year, and the notice was actually forwarded, and they actually showed up. However, in a short to our actual courtroom, in speaking with Mr. Manuel, it appears that they went to Judge Reeder's old courtroom.
On the 4th floor somewhere.
Yeah.
Okay.
And so And additionally, like when he first came into the building, Mr. Manuel, his mother, and Ms. Shine, the deputies at the front said, well, I don't think there's any court going on today, which I think kind of adds up because a lot of judges still weren't having in-court appearances like we were at that point in time. In support of the fact that he did try to come to court that day, I've shown to Ms. Hall a print up of a bank account that shows that they got a lift that was about $9 on September 8th. That's the way that he and Ms. Shine came to court. His mother drove herself and met them here at the courthouse. And they both will be witnesses to the fact that, hey, the deputies at the front, the metal detectives said they don't think it's court going on today, and that they then went to the old courtroom, but of course.
Okay, so I see, I'm seeing now, there was a final plea date in July. Mr. Manuel didn't show. Your explanation is notice went to the older address, not Richardson.
They said they don't recall getting that.
And then September, he did get notice and he did show up for another final plea calendar. But he showed up maybe at Judge Reeder's courtroom instead of here.
Now,
Okay.
I always attempted to contact him through Ms. Shine's phone. COVID money, that number got cut off. The number that he had for me, his phone, he had some numbers incorrect. The first 3 digits of my number are 841. I've shown this call. He had me say this 814. Every other number is correct in terms of my phone number. So it explains why I didn't hear from him at that point in time. And he assumed I would reach out to him, but
So he's not hearing anything. He thinks things are fine. Heck, the case is 6 years old.
Court isn't really going on, so he's not alerted to it. We don't. I think any concerns about him fleeing are mitigated by the fact that in the 3 years between that incident, the allegation, and the indictment, he was here. Since that point in time, he's attended about 9 court dates. And when he was arrested, I believe Ms. Shine said around Windsor Street, 4th Street, and they live in Mechanicsville, so that's hot skill in the jump away. So he's always been in the area. Additionally, his employer, Darren Fears, is here. Mr. Fears is a DJ.
Which one is Mr. That's Mr. Fierce. Okay.
Mr. Fears has said that Mr. Manuel has worked for him for about 10 years.
Doing what?
Setting up the speakers and equipment at the parties that Mr. Fears hosts. And he also does the hosting, which is, he holds the microphone and lets people know what's going on. So they do all that work essentially in the Atlanta area and occasionally in Macon, Georgia. So he's always worked. He's always come to court aside from when we had these issues that were kind of exaggerated a bit because of COVID. And that's essentially our argument, John, that he's shown that he wants to come to court. To make sure that we don't have any future issues, I have Ms. Shine's new number, I have his mother's number, I have Mr. Manuel's email address now.
And they've got your correct number.
They have my cell phone number. They
Okay.
text and call me a bunch.
841, not 814. Okay. I'm just trying to find a bond that had. Okay, so at one point you lived on Newtown Circle, and that's the old address, but now you are at this Richardson Street. It's in the system. I'll make sure we're not missing any apartment numbers. So I've got apartment 2, 251. Okay, that's where you live. It's where you are each night, more or less. Who lives there with you?
My fiance and my kids.
How many kids?
4.
Okay. All right. So Ms. Hall, that sort of makes sense. It's different explanations for different things. It is missing a couple court dates, but Mr. Franklin has actually some documentation that makes it understandable and credible. That said, Pretty serious charges. Mr. Manuel needs to be on point with this stuff. That said, they were old charges, and it is harder to remain on point for 5-6 years. So what's your thought?
Your Honor, the state doesn't object to the LTA being lifted or the warrant being lifted. I've spoken with Ms. Patel. She is still in court with Ms. Miller, Judge Miller, to wrapping up that case. But I told her everything that I had confirmed or saw from the defense counsel. We've been texting throughout with the lift receipts, the phone numbers, and everything he explained to you. And she's okay with lifting the warrant as well, it being her case.
Okay.
I don't know if just lifting the warrant, he would theoretically be back on bond on the paid warrant.
Well, that's my question for you is, if we lift the warrant, has the bonding company said, sweet, we got our money and we're done? Or are they willing to continue to be the surety?
I know they paid the balance. They were on a payment plan. I know that they paid the balance.
That's good, but the question is whether the bonding company, this is how bonding companies make money. You've paid them, Mr. Manuel gets arrested, they say, great, we're not on the bond anymore, he got arrested, he didn't go to court. They're happy because their bank account is full, but they are no longer willing to be the surety. I'm not saying that they have made that decision, but maybe through Ms. Shine or someone that can be asked of the bonding company.
So I think one thing that the court may be interested in is the possibility of releasing him again on a pretrial bond, through pretrial services. It would give the extra layer of, if somehow I can't get in touch with him despite having 3 people's numbers and 3 people can't get in touch with me,
right?
Not responding to email.
So what I can tell you is that none of these charges can I set a signature bond. There has to be a dollar amount under the law. And I've shared this with, I think, your supervisor, but 17612 was amended January of this year. We don't call it signature bond anymore. It's called unsecured judicial release with the onus on the judge. Fair enough. And there is a long list of what are called bail restricted offenses for which a judge may not enter a signature bond, illegal bond. If it's appealed, it'll get reversed and a judge looks like the judge is flouting the law. That list now includes all these offenses. When he first got his signature bond, Mr. Manuel did, 2018, that was not the law. It's the law now. Regrettably, from some perspectives, and good news from other perspectives, that list is being expanded to include entering auto and things like that. So it would be illegal for a judge to grant a UJR, signature bond, for entering auto. You can make it a nickel, you can make it $1, but it has to be a dollar amount. Could be through the sheriff's 10% program, so money can come back. But I share all that with you to say I do think that pretrial supervision is a good plan. That means it would need to go through the sheriff's 10% program because there has to be a dollar amount. Now, I'm not going to set a dollar amount that he can't make because the state is agreeing he ought to be reinstated on bond. And he was able to make an earlier bond, so he should be able to make this. But the dilemma we're in is if what Mr. Manuel wants to do is to go back up under the bond before, because that's with a bonding company, pretrial services won't get involved. So to get pretrial services, we would need to make it a new bond through sheriff's 10% program and just a dollar amount that the family can afford, knowing, unlike with a bonding company, that they get almost all the money back when the case is resolved.
Would the court be willing to set the bond, if it were to do a 10% bond through the sheriff's department, would the court be willing to set it at kind of a nominal amount, maybe $100 or something?
Close to nominal, given the situation, but I mean, these are also real serious charges, and so I need to balance how all that plays out. And the ability in the past to do what Judge Downs did would say $25,000 is a big number, pretrial supervision, but it's released on his own recognizance. That unfortunately isn't a legal option for judges anymore. for these charges, and pretty much almost all felonies now. And you can see the list, it's long, but these are certainly on it. So maybe if you could confer with Mr. Manuel and Ms. Shine, and I don't know if people on the call could text you to give me a sense of what is achievable. Again, knowing that almost all that money goes back into the pockets of the people who put it up when the case is resolved.
You give out 5 minutes, Sharon?
No problem. One more thing. Okay. Mr. Franklin, what'd you learn?
Yeah, so they had done a payment plan with the old bondsman, so it wasn't as they came with a large chunk at any point in time. I think they may be able to get $250, $300 up. So I guess we would ask for a $3,000 total bond for the pretrial, do this 10% program and pretrial services.
Is there a way to determine if second chance is still on this bond so that we would just revert back to this?
I can call and ask. Not possible.
I don't know how quickly they try to get off the bonds.
If you, I didn't print out that screen. I printed up our old booking screen. Maybe if you looked at the permanent booking screen on Odyssey, my recollection is it showed no bond. So in my reading is as if they were off of it.
Okay.
Because if we look at the bench warrant, there would not be a bond to make at that point. We would still have to set something.
Are booking screens under jailings? Where do you find a booking?
So go to jailings, and they have
And then click his booking number. Okay.
It says no bond, Judge.
Okay. Yep. I see that. Thank you. So they're done. Ms. Hall, do you have any sense of what the victim family perspective is?
I don't, but I can have the answer in just a second. Your Honor.
Okay. Mr. Franklin, what is the purported connection, if any? Is it strangers?
As I recall, the minor complaining witness is the daughter of a woman that Mr. Manuel is the daughter of.
So it's an ex-girlfriend's daughter.
Yeah, and it was an activity that's alleged that happened while others were in a hotel room.
Mr. Franklin, please go to the podium.
I'm sorry, Ms. Rivers. It is a ex-girlfriend's friend's daughter. So Mr. Manuel, the ex-girlfriend's friend, and her daughter
were in a hotel room.
Were in a hotel room, and they alleged that something happened, I think, in the bathroom.
Okay.
While everyone else was in the room.
Okay.
Your Honor, at this time, we're still reaching out to our victim. Well, Ms. Patel is still reaching out to our victim,
Okay.
so we don't have a perspective.
All right. And Mr. Manuel, you would go back to the address on Richardson Street? Okay, and you'd be able to work with the gentleman who's here. All right. All right. So what I'll do based on what Mr. Franklin has shared is set a bond where it's $500 for each count. And it will be through the sheriff's 10% program, releasing Mr. Manuel to pretrial supervision, and we'll start that at level 2.
Thank you.
So, Mr. Manuel, I'm sure Mr. Franklin's told you this, but you sort of used up your 9 lives with the bonds. If you miss court, it really doesn't matter if aliens abducted you. Your bond's going to be gone. I mean, I'm joking. If you're in the hospital and you can't be here, and there's documentation you were in the hospital, that's fine. But if it's, hey, I moved or I knocked on the wrong door, you're going to get notice in the mail. You've got the right phone number for Mr. Franklin. Mr. Franklin just told me in court that 3 members of your family, he's got their numbers. And so if people are dropping phones and this and that, it's on you in the end. So our next court date, you got to be in court 10 minutes before court starts. So I see your smiling face when we get started. Okay? And if you can't, you call Mr. Franklin so he can let me know, hey, he's stuck in traffic, he broke his leg, whatever the truth is. But you really should just put a cast on it and get in here and not miss court. All right? What is next? It was on for a final plea. That's not what we're doing today, but I guess we just ought to put it on we don't really do final plea anymore.
So the DAs at that point in time had changed a few times, so it's not like we kept restarting the conversation. So we're gonna have to restart the conversation with Ms. Patel. That's all I can say at this point. There are things that I feel really good about that I think it should be addressed, but
it doesn't seem like there's a
conversation about someone can say not the case to it.
Sure. And that's not a conversation with me. That's you and Ms. Patel need to acquaint her with the case. So I think we'll put it on a trial calendar because Mr. Manuel will be on bond. Then that there's really not a date certain, unfortunately. But I don't see the point in dragging everyone in here again because I don't know that Ms. Patel would necessarily have the opportunity or the focus to. And it's not going to be Ms. Patel in a few days. It's going to be someone else. It'll be Ms. McCauley. That may be your time to try to sort this out when Ms. McCauley gets on it. And she'll be handling Ms. Patel's docket in here for a couple months. But unless you think we ought to put it on we would call it inquiry again because we're not doing final plea.
No, I'm not sure because I haven't touched the case at least since last July because of the not being here.
Yeah.
I'm sure we're going to need to update phone numbers and that kind of information.
Okay.
In terms of substantive work, I don't know if there's much to be done other than me acquainting myself with the file.
Right. I mean, there's either a sexual assault kit or there's not. There are the people in the hotel room and maybe there was an interview at the Children's Center. Okay. Ms. Hall, anything you want to add on behalf of the DA's office in this matter?
Nothing further from the state, Your Honor.
All right. Thank you for parachuting in for Ms. Patel.
You're welcome.
I think that's it for the calendar. Ms. Hall, do you have anything else?
No, Your Honor.
Mr. Franklin, Mr. Daniel is still here. Mr. Daniels, if you want to chat with him, I've given you the paperwork. I'll file Mr. Brown's. So I'll get it to Ms. Nelson, but we'll get that filed. And I think that takes care of things. All right. Ms. Nelson, anything else before I let folks go?
Judge, I'm not sure if the family had a question. I see their hand up.
Mr. Franklin's going to reach out to them.
Okay. No, then I don't have anything else. Thank you.
Okay.
I have one more person talks on the back, and I'll tell Jermaine and I'll send you all the text.
Mr. Parrish, nice meeting you. We'll look forward to seeing you when your cases are on the calendar.
Thank you, Judge. I'm excited to be here. Can't wait to appear before you.
Great. Make sure you connect with Ms. Nelson today, okay?
Yeah, I've already gotten myself on the list. I'll make sure I give her my personal cell just in case there's something that comes up where I'm supposed to be here and I'm in another courtroom. It'll be easier to get a hold of me that way.
Great. Excellent. Or you just let Ms. Hall know you've now seen her ably cover for colleagues. So either way.
Absolutely. I have a safety net now. I appreciate it.
Good. All right. Thank you, everyone.